Hello viewers, friends, this is Dr. Kashinath Neharkar and I welcome you in my YouTube channel Law Education Volunteer Dr. Kashinath Neharkar at lecture series on property laws. Friends, in this lecture we are going to discuss the concept of transfer of property that is provided by section 5 of the Act. So friends, before that, please subscribe this channel and press bell icon to receive further notifications on latest videos. So let's start with today's concept. Friends, as you know, we are discussing this topic under Transfer of Property Act 1882. Basically, the act was enacted to regulate the transaction which is called as a transfer of property. So, to provide the mechanism or the process for the transfer of property without keeping any chance for future dispute. Therefore, we must understand what is that which is called as a transaction or which is called as a transfer of property. So, friends, the transfer of property is nothing but the transaction between the parties. It is a transaction between the parties to transfer the ownership of property or to transfer the property from one person to another person. Let me discuss this as per the section 5 of that act. So friends, as you know, the transfer of property is nothing but the transaction of transfer of property. Therefore, the act is applicable to transaction between a living person only. As you know, the Transfer of Property Act 1882 is applicable to the transaction that took between two or more living persons. So it is not applicable to those transactions that are affected or that are caused by the operation of law, by will, by inheritance, etc. Such transactions are not applicable. So all those transactions which are voluntarily, that are between parties to transfer their property, such transactions are covered by the act. Therefore, the transfer of property is nothing but the transaction of transfer of property. So in such a transaction, it is a transfer of any interest in the property. We have already discussed what is the concept of property, and property includes bundle of rights. Property includes bundle of interests. Property rights include bundle of interest. So the person may transfer all of rights that are available on that thing, that can be called all property rights can be transferred, for example by way of sale, etc., or that person may transfer single right out of that property. So it is a transfer of interest. So friends, that transfer may took place by various modes like sale, mortgage, lease. After in a relevant lecture we are going to discuss sale, mortgage, etc. So stay connected. Now we are going to discuss what is the definition of transfer of property that is provided by section 5. See, actually this definition is provided in two paragraphs. What the earlier definition that was provided by original act of 1882, then it was thoroughly amended in 1929 to include some provisions and to do away certain problems that were faced at that time. So firstly we see what is the definition of section 5. So as per this definition, in the following sections, transfer of property means an act by which a living person conveys property in a present or in a future to one or more other living persons, or to himself or it himself and one or more living persons, and to transfer properties to perform such act. See, the another paragraph, first paragraph is provided to define what is the concept of transfer of property, and second paragraph is provided who can be the parties to that property. So who is the person? As the transfer of property is nothing but the transaction of transfer of property between person, but who can be, who are those persons who can be the party to that transaction? So in a living person is explained. So in this section, living person includes company, association, body, individual, whether incorporated or not, but nothing here in content shall affect any law for time being in force relating to transfer of property or by companies, association, etc. So let keep the definition away and let me discuss the essentials of transaction of transfer of property, by which you can easily understand what is the concept. By the definition you just understand, see, the transfer of property is nothing but the act between living person to transfer the property. And secondly, the person includes natural person as well as the artificial person. These two things must be remembered through the definition. Apart from that, we are going to discuss what are the essentials. See, the first essential of section 5 is transfer of property is nothing but an act. It is an act. So the act is done by living persons. Act, action. So whatever we do, that is our act. So it is an act. The transfer of property is nothing but an act. So it is act to transfer. So act is always voluntarily. The act derives from the desire. Any act derives from the desire. When a person wants to do something, when he have a desire to do something, then his act follows that desire. Therefore the act, that act is to transfer, his desire is to transfer his property to that person who is ready to get ready to purchase it, ready to give consideration for that transfer, what the thing is. Then it is a process of transfer. So that is the process. Transfer of property is nothing but the process from by which for example, a person wants to transfer his property is transferred to B, and what the process through which they complete the transaction is called as a transfer of property, and the effect of that act is the transfer of property from one person to another person. So this is the act. Second essential is, this is an act between living persons, inter-vivos, and it includes juristic persons also. So friends, as we have discussed, the Transfer of Property Act is not applicable to the transaction between living person on one hand and the other person who is died. Such transaction is not considered, like the inheritance, will, etc. But this act is applicable to those acts of transfer between living persons only. Inter-vivos is very important. So that person may be natural person, like the persons, natural persons, man, woman, whosoever the natural persons, and it includes artificial persons also, company, association, person, etc. And such persons are called as a transferor and transferees. Such persons are called as a transferor. The person who wants to transfer the property is called as a transferor, and the person who wants to purchase the property, or the person who wants to get the property as per that process, is called as a transferee. And such transferor and transferee must be competent to enter into such a transaction. So as you know, this transaction is between living persons only. There should be the person who is the transferor, who is there to deliver the property, transfer the property, and there is another person who is there to receive the property. Then third essentially is, what is the effect of that transaction? Effect of that transaction, and the effect of that transaction is the conveyance of property. It means conveyance is nothing but the creation of new rights in the property. See, the conveyance is nothing but the creation of new rights in the property in favor of transferring. So the effect is the transfer of property from one person to another person, and it creates new title, new interest in favor of transferring. For example, seller, in the concept of transaction, seller transfers his property to buyer. So and buyer pays him the consideration. So as soon as the transaction is completed, buyer becomes the owner of that property and seller has to lose the property. It means the property belongs to buyer, so the interest is created in the property in favor of buyer. So the conveyance is there. So conveyance is nothing but the process by which the property rights are transferred from one person to another person. So this is and if we want to see whether a particular transaction is a transfer of property or not, we must go through the test, and that test is test to determine the conveyance. So the question whether a particular transaction is transfer of property or not, that has to be looked into from the point of this test, and see whether the test is whether the transaction passes certain new title or rights in the transfer of transferee or not. So the answer of such question will decide particular transaction as a transfer of property or not. So question is whether that transaction passes, creates new title or new rights or new interest in favor of transferee or not, and its answer will designate that transaction whether it is transfer of property or not. And if the answer is negative, such transaction cannot be called as a transfer of property. But if the answer is positive, that such transaction will be called as a transfer of property. See, this is the conveyance. The person is delivering right of key of house property to another person, so that can be the transaction of sale, that can be the transaction of lease. Then friends, we must see the another essential of transfer of property, and that is the subject matter of transaction. See, what shall be the subject matter of transaction of transfer of property? What can be transferred as per section 5? What can be transferred as per section 5? And according to this section, this essential, all kinds of properties can be the subject matter of transfer. It means all properties can be transferred except those which are made non-transferable by section 6 of transfer of property. So that property can be movable property, that property can be immovable property. So that can be the subject matter, but there are certain properties which are made non-transferable. Section 6 specifically deals with which are those properties which are non-transferable, and if such properties are non-transferable by section 6, that cannot be transferred by section 5 of that act. So that property may be non-transferable by any law for time being in force in India, or that property may be non-transferable due to the section 6 which provides specifically certain clauses like the sections 6b to h etc. These are some clauses which define certain properties as non-transferable property. Then next essential is transfer of present property. See what the section 5 of the act provides. It provides for the transfer of present property. It means future properties cannot be transferred. So only property which are existent at the time of transaction, at the date of transaction, that can be transferred. So this is the, it means future properties cannot be transferred, because the property is transferable only when it is in existence. So future properties cannot be transferred. So what the word that is used in a section 5 as property transferred in a present or future, that word is present or future, that word is connected with when that transaction shall take effect, when that right shall go to transferee, whether that shall go immediately or in the future. In that context that word is used in section 5, but it does not mean that future properties can be transferred as per section 5 of that act. Therefore one of the essential is that property must be existent. For example, if I want to sell my property, house property, that property must be existent at the time of that transaction. I cannot enter into a transaction of sale that in 2050 I am going to construct the house and then I will sell it.